the Friday webinar series of the EGROW Foundation. As a very brief introduction to EGROW Foundation, we are a research-based policy think tank where we believe that policy advice has to be based on robust research. We came into existence in October 2018. We started the webinar series as COVID set in. We are very fortunate. We have done about 215 webinars. And in these webinars, again, we have been very fortunate. We have been able to bring, as was our objective, research-based policy advice. We have been able to bring the best researchers on different contemporary issues to discuss various aspects, both domestic and international. So we've been very fortunate to have a blend of foreign scholars, Indian scholars working abroad, so that we can talk about contemporary economic issues and discuss them threadbare. We have been also very fortunate to have the blessings of 3 Nobel laureates who've come and spoken on our webinar series in the last 2-3 years. We had just concluded a series of discussions on poverty, multidimensional poverty especially, and Professor Nanak Kakwani came for 2 webinars on that. We also had Sabina Alkire from London School. We were again very fortunate to work as a think tank for the G20, for the new international economic order. We did a series of 11 webinars for them. And under the themes of G20, we also worked on women empowerment and climate. As you know, things are becoming very complex, and I come from the financial world where I constantly feel that law and economics are not coming in together. With this background, very recently, Mehta ji came out with a book, Supreme Court and the 6 judgments. We encashed on that, and we invited him to come and present his book at our EGROW webinar, and he kindly consented. And then whom else could we bring to bring in this view of law and economics? So I invited my dear friend Professor Ram from D School. He's heading it, of course, but he's a dear friend, and I requested him if he can come and chair the session, which again I was very fortunate he agreed. And then we have 2 discussants again, my 2 dear friends, Mr. Chopra, whom I know him from 1977, and Devi Prasad, whom again I know him for more than a decade now. So let me briefly introduce all 4 of them before I hand over the session to Professor Ram to conduct the proceedings. So Professor Ram is director of Delhi School, as I just mentioned, and he's been a professor who has been writing and researching very scholarly. He did his PhD from JNU and postdoctorate from Harvard University, and has been a fellow at London School of Economics. He is a recipient of several awards and honors, including Fulbright, Commonwealth, Erasmus Mundus, and other fellowships. He has taught at Brown University, Universities of Hamburg and Heidelberg, amongst others. He has published extensively in leading international journals, including Journal of Economics, Journal of Law and Economics, American Law and Economics Review, European Journal of Economics. So that is the very reason that he brings in a blend of economics and law, and has published at international level, that we wanted him to come and chair this session. The key speaker, our main speaker today, is Mr. Pradeep Mehta. He is the founder, Secretary General of the Jaipur-based think tank Consumer Unity and Trust Society, CUTS as it is popularly called, a global economic policy research, advocacy and networking NGO established in 1983 in India, with centers in Nairobi, Lusaka, Hanoi, Accra, Geneva, and Washington, D.C. Currently, he is member of the WTO DG's NGO Advisory Board for the 3rd time. He also serves on the G20 B20's Council on Africa's economic integration. He has also served on Government of India's boards of trade, He has been actively participating in policy making in our country. I've known him, seen his research when I joined IIM Bangalore, and very impressed with the type of work that he's been doing. Our first discussant today is Mr. Devi Prasad. He retired from the Indian Economic Service after an illustrious service of over 30 years. He was the founding director of the Fiscal Policy Institute, Bengaluru, which is a beautiful institute. I used to visit regularly, speak there while I was at IIM Bangalore. And he has served as advisor to executive director at the International Monetary Fund, Washington, D.C. Of course, because he's from the Indian Economic Service, he carries vast experience on different aspects of the Indian economy. He has been delivering lectures on fiscal policy, budget management, macroeconomic management, public policy, public financial management, and so on the macro issues. The last discussant for the day is Professor R.K. Chopra. He is a doctorate in telecom laws with post-graduation in electronics, management, and law, having experience of more than 4 decades in academics and corporate, including client consulting, contracting, and technology companies. He has been professor of law at UPS Dehradun from 2018 to August 23. His subject interest being corporate law, constitutional law, IPR, comparative public law, and research methodology. With this brief introduction of the 4 on the panel, I would now like to hand over the session to Professor Ram to conduct the proceedings further. Professor Ram.
Thank you, Charan, for this very warm welcome and extremely kind introduction, which is kind at the same time fair and representative of CVs of 4 speakers on this panel. Thank you so much. I would start by complimenting Charan that you have been very, very active and covering almost all aspects of economy and also polity and also society. Here today, with this panel discussion today, you have filled a deep, significant gap in the public discourse on policy issues, which is law and economics. Some of us realize how important the understanding of economic reasoning in legal decision making is. But this is one issue that remains underappreciated among economists, among policymakers, and more importantly, among the judiciary. Judicial pronouncements make significant impact on our economic lives. And very few judges, very few economists have appreciated and talked about it. In that sense, it is of immense value and immense sense of appreciation. I thank you for organizing the talk. And the talk by someone who is as popular as his organization is, Cuts and Sri Pradeep Mehta. They are both household names. They both, Mr. Mehta and Cuts, have been around proactively dealing with a wide range of public policy issues. I remember reading his writings actually more than a decade ago about economic dimensions of decision makings by Supreme Court. And more recently, Cuts has come out with a significant volume that has been published by Niti Aayog. And I understand now that volume has been published as a book also, wherein Mr. Mehta talks about the 6 very important judgments that have shaped economic landscape of this country. With discussions like this, my sincere hope is that there'll be better appreciation of economic consequences of judicial pronouncements, and therefore some appreciation of need of using economic logic when judiciary comes out with their important pronouncements in host of issues, be it matter related to property, be it matter related to environmental damage, or even contractual and procurement issues. The public procurement accounts for around 20%, 18 to 20% of GDP. And most of public procurement happens through contracting. A bid starts with bidding, but ultimately some contract kicks in. And those contracts are interpreted by higher judiciary. How Indian high courts and Supreme Court are going to read contractual clauses, whether the risk allocation is appropriate or not, whether the contractual obligations are enforced or not. It will have significant, very important consequences for Indian economy. And so it's with this background, I welcome Pradeep Mehta ji to share with us his findings on economic dimensions of important Supreme Court judgments. I also welcome Sri Devi Prasad ji, who has a very rich experience with policy making from economics viewpoint. And we are lucky to have a professor of law, somebody who is a doctorate, who has formal degrees in technology, also a professor of law. So this kind of blend is what we need for a wider public discourse on interdependence and interdisciplinary nature of law and also economics, and thereby law and economics. So welcome, I welcome you all. Now the floor I hand over the floor to Mr. Mehta. Pradeep ji, maybe you can speak for about 40 minutes. Will that be right, Charan? For about 40 minutes for Mr. Mehta, followed by 10-12 minutes for each discussant. Okay.
Thank
Floor
you.
is yours.
Thank you very much, Chairman. And let me also add my warm greetings to the fellow panelists or discussants who are here to hear my version of the book that we have written. Now, this is the story of the economic impact of 6 landmark cases of the Supreme Court, as has already been said by Professor Charan Singh. And let me also thank Professor Charan Singh for having invited me to this webinar, which I seem to have missed. I may also add, since academic qualifications were mentioned for all, I've been a visiting fellow at the Loyola University, Chicago, and also visiting fellow at the Manchester University. I don't flash my academic qualification because I'm an activist and I'm more busy pursuing public policy advocacy work. Anyway, I thought I'd just let me mention it so that my depth is understood properly. Having said that, can I have this next slide, please? Now, the book that I wrote was, let me share with you the origin of this book actually began with the Prime Minister. And this is a work that we got from Niti Aayog as a consequence of the Prime Minister's concern that many of the judicial decisions are impacting the economy adversely. And that, there is a need to debate this, and therefore I'm very happy that this is probably the first public debate which is going to happen. And we are hoping, unfortunately, the elections came around at this time, that we were going to have a public release of this book by dignitaries. Unfortunately, that has got postponed to sometime in June or July, and I hope to invite you again for that. This is a bit of a background in the sense that, environment, economy, and equity concerns are increasingly getting intermixed and posing complicated questions for courts. To put it simply, there are environmental issues which have been taken up very rightly. If you look at the latest case before the Supreme Court, when they announced the issue on the protection of the Great Indian Bustard, and so on, as to why is it important that all environment is so important in order to understand the consequences for climate change. That is something which the Supreme Court has been well known to raise this issue. But what is important is that Supreme Court, when it looks into all these issues, and particularly some of these contractual issues, they have not looked at the livelihood dimensions. Now, there is always a balance between environment and livelihood. You cannot have, I mean, as I say, that the whole agriculture itself is a big intrusion in environment. Now, agriculture has come around because of the fact is that people need to eat. They need to fill their tummies. So you do have this intrusion in nature, which has been happening over centuries. It's an evolutionary issue, so we cannot have a very blind kind of concern or blind kind of understanding of any of these issues. We have to have a balance of environment and livelihood. Now, we are aware that Supreme Court decisions have far-reaching consequences and impact those who are not directly represented. For example, as I said, just in terms of very large number of labor has been affected by many of these decisions. Consumers, labor, society, etc., etc. Now, what is our argument is the decision must take into account socio-economic realities, and the implementability as well as whether the objectives can be achieved. And there is a need for a structured and evidence-based economic analysis to minimize unintended consequences. Unintended consequences are many. This book reviews 6 Supreme Court decisions from these lenses, highlights impacts, and suggests possible alternative approaches that could have been adopted. So we have not stopped at criticizing, but we've also suggested alternatives. Have a look at the book. It is available on Amazon and Flipkart, both, including for the sake of knowledge sharing, we have put it on our website. There is open source as well. It's free. Anybody can download that book, and you can purchase a hard copy from the market as well, Amazon or Flipkart. But it is available free of cost also. Next, please. Next slide, please. Now, the 6 cases are, first is the ban of liquor sale on highways to curb accidents, whether it was justice or disruption. The second case is on public health and emission standards, the ban on non-BS4 vehicles. Vehicles which are not adopting or not complying with the Bharat Standard 4 in terms of the emission standards. Third is the coal block allocation. Could the Supreme Court have salvaged the situation? The fourth case is on the 2G telecom case, a labyrinth of policies, procedures in place. Then the fifth case, which is a kind of a very troublesome case, an adjusted gross revenue case. Right? It is this one which is in search of destination without definition. Finally, the positive case among all these is the Shiv Shakti Sugars case, where the court went into economic consequences and addressed them and we thought that this can become a good lodestar or a guiding light for the Supreme Court in other cases. Unfortunately, we did not see the impact in the court, and that is again a very structural issue. Is a good judgment like this should have become a part of the education of the Supreme Court judges, who, of course, often feel that they don't need any more education, which is a tragedy. Now, we have done another 5 cases after this judgment came out, which is going to be a second volume, which will be turning out very soon. So I leave it at that, and let me go ahead with the presentation as I have listed out here. Next, please. Now, there are 3 broad principles on which we looked at the economic impact. The first is the legitimacy issue. Did the court go beyond its remit? For example, the adjusted gross revenue case in the case of telecom revenue. When the telecom regime shifted from a license fee to revenue sharing fees, there was a lot of confusion created by the bureaucracy in that. And did the court handle it properly or not? I don't think so. Did the court substitute its judgment for a policy decision or expert opinion? For example, in the coal case. The second touchstone that we looked at is suitability. Is the decision enforceable and implementable? The non-BS4 vehicles, for example. The second principle and the suitability was, can the decision result in the desired impact? Liquor ban, for example. There was no impact at all. It is just, in fact, what happened was that the black market expanded as a consequence of this. Are alternate remedies available to achieve the intended objectives with lesser disruption in both the 2G and the coal block case? That is another important touchstone. Then the third principle we looked at is proportionality. Can the decision have unintended consequences, particularly on stakeholders not parties to the matter? For example, the liquor ban. Are sanctions proportionate to the fault or some genuine entities penalized, say in the coal case, for example? Are some guilty parties, government officials, politicians not sufficiently penalized, like in the 2G case? A high corruption matter which happened. But that was a typical case where the Supreme Court decided to cancel all the licenses without realizing the consequences of that particular decision rather than finding a better way out. Having said that, let me move on. The next, please. Next slide. Now, the key findings and suggestions in these cases, in the liquor ban, was the implementation challenges requiring further court directions. There was this confusion about 500 meters or highways in the city and so on and so forth. And then again and again, there was no significant reduction in drunken driving cases after the decision. There's another important aspect in this is that they talked about liquor ban, but without realizing that there are other toxic substances which drivers consume, like ganja or afim or what have you, that could also result in negligent driving. Now, what happened as a result of this ban was that there was excise revenue loss to government and impact on the hospitality industry in a bad way. It was a multifaceted issue requiring a collaborative approach rather than a danda approach. Expert committees could have engaged in comprehensive expert consultations, including on enforceability. Now, what is interesting in this particular case is that there was a Supreme Court Committee on Road Safety which was sitting, which had recommended a liquor ban for 150 meters from the highway, which of course the Supreme Court went up to 500 meters. And the surprising part was there is a Supreme Court committee which is standing, and the Supreme Court, when dealing with this issue, does not even refer to that committee or the recommendation of that committee. I don't know why. Where is the disconnect? If at all there is a committee headed by a brother judge of the Supreme Court, then that matter should have been referred to by the Supreme Court and looked at. Now, the Committee on Road Safety was constantly advising state governments to implement some of these rules, but they did not happen. The rules itself was impossible to implement. Now, what we require is, we have to look at what are the global best practices in order to ensure that done. And there are very good case studies that we came across from Australia, from US, etc., which achieved the objective of reducing drunken driving without these kind of irrational orders. Now, the next case on the BS4 standards, emission standards. There was market uncertainty and panic. There was cut-off date decided very fast. Now, cutting off the emission from vehicles alone is not the cause for the problem of air pollution. The problem of air pollution still remains. That is just one of the factors. Now, banned vehicles sold before cut-off and resold rate was at a highly discounted rates because they had to get rid of the stock. There was a huge loss incurred by the automobile sector, both manufacturers and dealers. There was loss to auto and two-wheeler industry and increased cost to consumers. The increased cost to consumers and difficulties in vehicle registration also. For example, there was a confusion about registration of tractors, for example, whether tractors will come under this category or not. There was no clarification. It did come out subsequently, but what I'm saying is that created a lot of difficulty. Court could have penalized the defaulting manufacturer through heavy fines rather than stopping the sale. This is a kind of remedy which cuts across most of the cases, rather than finding a remedy which does not affect the production or the consumption or the process. Is better than to say that, look, you stop it completely. Next, please. Next, please. Yeah, coal black allocation. Could the Supreme Court have salvaged the situation? The court substituted the government's judgment with its own on allotment route. That is not a job of the court. It's a policy decision. Having said that, the impact across sectors like power, metal, finance, trade imbalance, fiscal, debt loss, investments, and jobs. And there's a widespread adverse impact. Court could have focused on identifying and separating the guilty parties from the rest. Here again, they sort of used one paintbrush. Expert committee could have been set up to examine the merits of each case, each coal block allocation. 2 books have been written on this by 2 of the former coal secretaries. So there's enough material on this and I've used references from both these books this is one is I'm forgetting the names at the moment. Sorry?
Excuse me, other than the speaker, please let us all remain muted. Let's mute ourselves. Only
Right.
Mr. Mehta will remain unmuted. Yeah, please carry on.
Right. Now, there was unjust enrichment resulting from corruption ought to have been verified through a criminal inquiry first. The penalty amount could have been deposited in a fund like a consumer welfare fund rather than go to the treasury. The 2G case, again very interesting. There was impact on investments, competition, consumers, financial sector, infrastructure, and international relations. International relations, particularly, there were a Norwegian company, a UAE company, and a Russian company. All had to pack up. And that had an impact on our international relations as well. The court could have singled out corrupt officers rather than quashing all licenses and allocations. Corrupt officers and ministers. Of course, the minister had to face inquiries at a later date. Now, only those licenses should have been cancelled where companies unduly benefited. The court could have singled out those particular things. And there are examples of that given in my book as well as in court order as well. Investigation of entities and officers unfairly benefited could have been undertaken also. Team to identify whistleblowers, insider approvals could have been constituted to trace the money trail. Law should be enacted making all contracts involving corruption void and unenforceable, and a windfall profit tax should be imposed on licensees making huge profits through offloading without value addition. And there was a very good case of that companies without any experience with telecom. That's not that it matters. Deep pockets is what is required in order to run the telecom company. They got licenses and they sold it at fabulous profits. And this is where one of all the 3 international companies are also involved: the Russian, the UAE, as well as the Norwegian companies. Having said that, let me move on. Next slide, please. Now, the adjusted gross revenue case. There was an impact on telecom sector, jobs, competition, financial sector, consumers, etc. As I explained in my opening remarks, this is a very interesting case where the government under Vajpayee and the then telecom minister, getting into amnesia about names. Anyway, they decided that, when the mobile telephony license sector was opened in India, they auctioned it off with a heavy license fee. Now, in the beginning, of course, the market could not be exploited by the 22 licensees in the manner that they could, and all of them ended up in a loss, and the sector would have collapsed. They went to Vajpayee, the Prime Minister, said, look, can you can we change it to revenue sharing, which will probably be easier for us to meet with? And that policy decision was taken. I thought it was an excellent decision. And even though it could have been criticized that you shifted the goalpost, unfortunately, there were no bidders earlier who were dissatisfied with it because all the bidders had got some license or the other. Otherwise, it could have led to further problem that look, you're changing the conditions of the license and without giving us the opportunity to bid for it. But anyway, that did not arise. But what did happen was the idea was that the revenue share will be done. The understanding given was that TRI will decide it and that it will be transparent, etc., with consultation. But here the bureaucracy really played foul. They did not, they said, look, all gross revenue, whether you sell scrap or you sell whatever services which are not your telecom revenue or not your operational revenue, will be treated as part of the revenue. You have to give a share of that, which is very unfortunate. Even if you look at PPP contracts today, for example, in an airport, it's only the aeronautical services which are subject to the PPP thing and not the ground side services. Anything with, say, parking or shops, etc., which the operator runs, that revenue is, or the profit from that revenue is not shared with the government, except on the air side. So there's very, very good clarity, and there are very good policies like that. Unfortunately, this was messed up, and this case is really interesting to see how the court, messed up, and they could have, been a little more understanding the matter, but unfortunately, as in many cases, egos just played there. And the DOT suggested a particular period, and the Supreme Court came down heavily. He said, look, how can you do this when we are considering another period, etc., and so on and so forth. The bureaucracy, subsequently, I'm talking about the current bureaucracy, which suggested a better way out. Today, today we don't want a reduction in the number of players. We have only 3 private sector players with 1 public sector player, and even that public sector player is not allowed to invest. It has not gone ahead from 3G. It is still in 3G, BSNL or MTNL. Now, that again is a matter of corruption. That's another story. I'll not get into that. But here now, Jio came into the picture late. Airtel has been able to stand competition from Jio. But Vodafone was in very strong sort of up the gum tree, I would say. Finally, they've been able to manage one way or the other and are reviving. And we do need a minimum number of players to ensure that there is competition in the marketplace. And this particular court thinking did not even look at this particular aspect as to what are you doing? Are you going to kill the sector or what? Now, the last case, which is the icing on the cake, as I said, was Shiv Shakti Sugar's case. Justice Sikri went into it in great depth and looked at it that, look, we have to interpret a particular provision looking at the economic impact and effect of a decision has to be kept in mind. And it said the court should avoid an outcome that can adversely affect employment, growth of infrastructure, economy, or revenue of the state. A wonderful judgment, a very visionary judgment, very thoughtful judgment. And they looked at Article 142(1) of the Constitution, which allows the Supreme Court to look at complete justice, which is what the court has just looked at in a very peculiar case right before us. What is happening today is this, which is very peculiar in my opinion, where the Supreme Court has turned down the Delhi High Court's decision in a dispute between Delhi Metro, DMRC, and the Delhi Airport Metro, the train service. 12-year-old tribunal order which has been held right has been turned around on basis of 142. This is what the Supreme Court argues in this particular case. Now, that itself is puzzling, but that's not a part of this presentation. But as the latest case of using 142, 142, as I said, allows the Supreme Court to look at complete justice. And I mean, you know the language, most of you who are familiar with it. etc., which has to keep in mind that the court can look into all these issues. They are authorized even under the Specific Relief Act. There is a provision to set up expert committees. So all the provisions are there. Yeah. Now, what I would like to submit is, we looked at 5 other cases. I'll be happy to speak about them on some other occasion after this Renuka sugar case, to see whether there was an impact on the other thing. Unfortunately, not. It is a great tragedy. I don't know how does our Supreme Court function. There is a wonderful judgment which should be imbibed by other brother judges, but unfortunately nobody's even looked at it. Having said that, can I move on, please? The next slide. Next slide, please. Now, what are the systemic solutions for better judicial response in economic matters? I've listed out a few of them here. Conducting impact assessments, appointing a committee of experts to carry out cost-benefit analysis, or engage experts who can provide evidence about possible economic impact. The expert can also be appointed on the appellate side to hear cases, which is what our court is not doing, but many other courts in the world are appointing economic experts on the benches. Second is to consider alternate remedies in interest of multitude of stakeholders directly and indirectly involved. I gave you that very simple metaphor of environment versus livelihood, which have to be kept in mind. And to undertake ex-ante assessments of enforcement challenges to the decision. For example, the liquor ban. There was no ex-ante assessment whether it could be implemented at all or not. And this is one particular judgment. We did a lot of field work in this in many parts of northern India. There was limited budget, so you just could not do it in all India. And to see even at night in a traffic check post, the police said, "Okay, you want to check drunken driving? We go and smell their mouth. Can you do it? How much you can use this?" So I mean, it was impossible to implement. And the court did not even think as to whether the court has to look at the implementability of its decisions before making an announcement. And that is very important. They can talk to experts. So what can be done, what cannot be done. They can talk to civil servants who would probably have a better understanding about implementability, whether it can be done or not, before passing an order. Now, one of the suggestions we've had is something which has been debated in India for not very much, that to have split the Supreme Court into 2. One is the Constitutional Court and appellate courts in various regions. The appellate court can have dedicated regional and central chambers on commercial and financial matters. It could be a dedicated chamber. This is there as per the Commercial Courts Act. High courts have to establish benches for commercial matters. I don't know how many have done or not, but it's still moving very sluggishly. It's just not moving at all. The second is to end vacations, We have to focus on improving competencies in lower judiciary and adopt case management policies, which is just not happening in India. There has to be unprecedented fines and penalties on officers, which can be work like a disincentive, including by invoking doctrines of public accountability and equal fault. We're also talking about disgorgement, which has not been happening very systematically in India. It just happened on an ad hoc basis. Finally, institutionalized dispute assessment through independent committee of experts from diverse backgrounds. Finally, there has to be research and accountability standards to set up national research unit with professionals from the law, economics, finance, and political science, tasked with developing an integrated analytical unit in the Supreme Court or the Law Commission to monitor and evaluate cases. This has to be done on a constant basis. This has not struck the court. And to publish regular reports highlighting the effectiveness of different judgments on the wider economy. Why can't? There's no harm in publishing white papers. The court can publish white papers on any particular judgment that has happened, and to see as to what was the sort of impact on the economy and the society for wider public debate. After all, the Supreme Court is a public institution. It is not a private institution that it doesn't have to put out its own. I mean, this kind of intellectual output needs to come forward from the highest court in the world on a regular basis. Particularly, they should analyze good judgments and bring forward these papers. Next, please. Next slide. Now, awareness generation among stakeholders and judicial officers on economically responsible justice. This should be done by all the judicial academies and events like the one we are now speaking at. Stakeholders and judicial officers' capacity should be built up on to conduct economic impact analysis of decisions, including, as I said earlier, a little while earlier, was this could be done even under the aegis of Supreme Court if it agrees to do it as an intellectual exercise. Publish white papers on orders, which including looking at pros and cons. It doesn't have to be necessarily judgmental, but it has to be sufficiently exposed. Now, examining recent developments highlighting complex integration between law and economics. Now, the Supreme Court has recently realized and has pronounced that citizens have to be free from adverse impacts of climate change. Now, the Supreme Court has also proposed judicial oversight in cases probed by central and state agencies. Now, as I said, I spoke about this particular thing, that the Supreme Court reversal of its order when it asked DMRC to pay arbitration award of 8,000 crores to Reliance Infra, which I found was very peculiar. Calcutta High Court ordered cancellation of 25,753 appointments for school jobs in West Bengal. Now, the point which the High Court said was that these were all done through some kind of irregular method, and therefore it should be cancelled. I don't know what happens to the fate of these 25. There are similar cases happening in Rajasthan as well, but I leave it at that. Can the court consider a private party? Can it be submitted? Can be considered as a community resource? Now, on demonetization and electoral bonds, the Supreme Court had a very good thought process. Supreme Court is to rule on hospital pricing. Does it come under the jurisdiction of the judiciary, or should it be taken up by the policy apparatus, which is the government, the executive? In the Great Indian Bustard matter, the Supreme Court recently said the decision on whether to convert the overhead power transmission lines into underground lines is a matter of environment policy. While adjudicating writ petitions which seek relief, which are of nature sought in the present case, this court must conduct judicial review while relying on domain experts. Those who are equipped and trained to assess the various facets of a problem which is litigated before the court must be consulted before a decision is taken. If this is not done, the court may be in danger of passing directions without a full understanding of the issue in question. Consequently, in the absence of evidence which forms a certain basis for the direction sought, this court must be circumspect in issuing sweeping directions. Excellent order. Now, the point here is that the Great Indian Bustard matter in shifting of the apparently those who own the overhead transmission line, the problem of shifting it underground is very costly. There are other methods by which you can protect the dying species of Great Indian Bustard. This is reducing, I would say. They're not dying, but they're nearly dead. And the fact is that they have to be protected, so there has to be. For example, now in many of our highways today, what has happened is, which are passing through forests, there have been underground sort of roadways made for animals to cross, so that they don't have to go on the. So there are ways as to how we can, deal with this particular matter, which requires experts, domain experts. Now, domain experts would be who? Would be civil engineers, would be economists, would be financial experts to deal with all this, to look at the cost benefit of, what could be a better way to do it or not. Finally, the next step is that we need to undertake more such studies, and including be able to turn them into information dissemination materials, as well as training materials for judges across the country through judicial academies. With that, I think I've come to an end. The next slide, please. Thank you. Thank you, Ram Singh ji.
Yes, very, very fascinating, Pradeep ji.
Thank
Can
you
we
very much.
now- Yes, before we have Q&A session, let's hear from our discussant. Prasad ji, I
Thank you.
invite you to share your comments.
Thank you, Professor Ram Singh ji. And I'm delighted to listen for more than 35-40 minutes to Dr. Mehta. And it was very interesting, absorbing conversation. Presentation is very good. Though I must confess, I did not have a chance to look at the book. I ordered on Amazon. It may come tomorrow. I'll definitely read and get back to you. Before coming to the contents, I make three points. One is Constitution is a political document, is a legal document, is a social document, and also economic document. And today's discussion is more focused on looking at the Constitution and the role of Supreme Court. Role of Supreme Court and looking at the Constitution as an economic document. Because every decision, or most of the decisions, have economic impact. That's one. And it flows from the presentation that it is a litigation, and decisions on the litigation is what troublesome sometimes, which can be preempted through some ex ante measures. Now, 13th Finance Commission in the year 2009 suggested state and central governments to have a litigation policy to speed up disposal of the cases and also to avoid unnecessary litigation. And it is found subsequently in economic survey also, I think 3-4 years back, that government is the biggest litigant in various courts. Now, how to bring down litigation load on the courts? I think that should be one of the recommendations that can go into that. But though it happened in 2009, 13th Finance Commission, I don't think states have established and central has established a litigation policy formally and following it. And the third one is ex ante appraisal. Yes, that is required. Now, ex ante appraisal of court decisions is one, but ex ante appraisal of legislation itself is warranted, and which is unfortunately missing in our legislative history. I recall there was a committee or commission under chairmanship of Justice Venkatachalaya, on this aspect, that ex ante appraisal of proposed legislation should be done, A, to look at the cost of implementation, B, on the enforcement challenges of the law. I don't know what happened to that committee report or whether ex ante appraisal is happening to the bills that is brought. But superficially, from what I gather, not as a scholar, but from general reading, ex ante appraisal of the bills is almost not existing. I'd be happy if anyone says this is particular legislation has undergone ex ante appraisal. What happens in ex ante appraisal of legislation? That appraisal will become handy for courts when they are looking at the litigation related to that legislation. This is one requirement. And coming to ex ante appraisal of Supreme Court decisions and establishment of a dedicated research or analysis cell or unit or whatever you call it, is warranted, but whether it's under Supreme Court or independent of Supreme Court or High Courts is a different issue. That can organizational dynamics can look into that. What happens in looking at impact, there has been cost benefit analysis, as you rightly mentioned in the book. Now, cost benefit analysis has to look at Pareto optimality. And it depends on various assumptions made for cost benefit analysis. For instance, costs may be borne by many, benefits may accrue to few. One scenario. Second, costs may be on many, benefits may accrue to many, which is an ideal situation. Secondly, costs may be on a few people, few groups, few people, few regions. Benefits may accrue to many. And costs may fall on many, but benefits may accrue to few. And fourthly, costs may fall on few, and benefits may accrue to a few, which is undesirable aspect. Now, this requires certain assumptions to be made for any cost benefit analysis. Now, how accurate, how realistic, and how reasonable and defendable is what matters in the analysis. So therefore, there has to be a standard manual for ex-ante appraisal. And who will make that manual? If any other country has such a manual, I think there is an orange book in USA, in UK, for budget analysis. What is the impact of budget allocations? That is measured through orange book manual. That has to be looked into. And one of the judgments, perhaps, which need to be looked at, taken seriously, is Supreme Court judgment on February 12, 2012 on Ganga Kaveri link. That was a very reasonable judgment. It has seen every aspect of it. NCR has given their project, this appraisal report. Decision was given, but now it's 12 years. Nothing is moving much forward. Water sharing issue is discussed in that. So I look forward for the book, and also look forward whether the book discusses Pareto optimality and ex-ante appraisal of legislation itself. And again, we would have a chance to meet and discuss in person. Thank you.
Very good. Thank you, Taji. You have made several insightful comments and observations. I now invite Professor Chopra to share his comments. Professor Chopra, maybe 8-10 minutes.
Right, sir. I think my part has become very easy because Mehta ji has explained so well the cases and the subject of law. I'll just touch upon very few pointers. If you talk about the preamble to our constitution, it talks about the justice, social, economic, and political justice. And if you talk about the economic justice, the entire work which Mehtaji has mentioned is mainly on the economic justice. That means whenever we are doing a justice, I just give you a very small example. When the constitution was created and Article 21 was framed, and there it mentioned that our Article 21 says personal liberty. It mentions that every person has a right to life or of personal liberty except procedure established by law. The word procedure, when this drafting committee was there, B.N. Rao was asked a question from Ambedkar and others, why don't you discuss across the globe? And during that time, he went and met Justice Frankfurter, who happens to be earlier the professor of law and then became the Chief Justice of the United States. He said, you as a India have just got the independence, and therefore at this very first stage, it is better to keep the word procedure only, and that is how the cases like A.K. Gopalan and other things started working and moving on. That means if there is a preventive detention law, you apply and do it. But from 1978, from Maneka Gandhi case onwards, and when we, Mehtaji has also mentioned the recent cases about the right to environment and health and all those issues. The question is, when the society is developing, it is developing not of its own. When we talk about the needs, when the people are educated, it is equally true about the economics. That means, say for example, when we don't have the money as a country as a whole, 26th Amendment came when the privy person's rights were stopped. And recently, there is a famous case which is presently lying before the Supreme Court to review the observations of Justice. Hello, am I audible?
Exercise करें
I'm getting some voices, please.
दोबारा तो पूछिए
Yeah, now in
Mr.
the
Salim,
recent,
please mute yourself. Professor Chopra, please carry on.
thank you, sir. Now, this was a case which is presently before the Supreme Court, where the 9-judge bench has been constituted to see the judgment coming out of state of Karnataka versus Shri Rangareddy and others of 1978, wherein Justice Krishna Iyer mentioned that what about the material resources? He says that the material resources could be of community, which could both include the natural and man-made. It can be public as well as private owned resources. And my earlier discussion has beautifully mentioned that, you know, how these balances could take place under all the four situations really need to be appreciated. Here the Supreme Court, this is still ongoing, which is a large constitutional bench of 9 judges, where the word economic, the material resources, which mentioned under Article 39 B and C, and which is really nowadays, if you see, is also a part of the manifesto of some of the political parties. What it says, 39B says that the ownership and control of material resources of the community has to be so distributed so as to best subserve the common good. Now the question is, material resources of the community. Now the question is whether the material resources of the community could be equated to the material resources of the individual. The second aspect could be, which is very, very essential and important for our entire discussion, is that the operation of economic system should not result in the concentration of wealth and means of production to the common detriment. And to be very honest with you, Mehtaji, whatever cases, all 6 cases, apart from this, I think he has already submitted a report to the Niti Aayog on various other cases as well, opens out a Pandora box in a sense that whether he discussed on the liquor sale case, that is of 2016 judgment of state of Tamil Nadu versus K. Balu, wherein when it mentioned that restaurant near the highways lead to the drunkard driving and there could be more fatal accidents, and the manner even in January 24 and February 24, whatever the Supreme Court has mentioned about the distances and all has got no economic basis. I say 2 things here. Number one, like say for example, when Mehtaji talked about the 2G case, or in any bidding process, when the bidder bids for a job, it is important to do the economic analysis both by the bidder as well as by the government department. Because here one of the very important provision, which is normally is not in the construction sector, but which is very well there in the IT sector, that is not covered here because of the domain which we are taking into consideration, is where the time as a sense of the contract, and it not only charges about the general or the nominal damages,
but also the special damages. Mehtaji's study talked about, the losses of say around 20,000 crores if this could have been implemented, and he has also given the empirical analysis of those cases. The question is, when the clients issue a job, because most of these cases were all the state operated cases, what is the economic basis they have done? And if there is a delay, if there is a fault, if there is a risk and cost provision, what could be the situation? The another point which is very, very essential is, and I think most of us are aware, but if a contract is done under a fraud, it is not a void contract. It is voidable contract. Say, for example, you have already made a highway which is completed, say 90%, and now you found that the turnover of the contractor was not okay, or his the net worth is not fine, or his consortium partner is already under the liquidation process. As a strict Sarkari Babu, somebody will just close it. Perhaps that is not required, because a voidable contract is at the option of the party who has suffered to the extent whatever they want. If they want, they can still continue this. Finally, before I close, I will say only one thing, that high courts have already the commercial codes. Construction Industry Development Council way back in 2003 had mentioned that in the construction sector itself, this was the study made by the then Secretary General, Mr. Udesh Kohli, wherein he mentioned that in the construction industry in 2003, more than 23,000 crores is lying in the litigation. My submission is that the bodies like CUTS or the EGROW, similarly CIDC, Department of Law, various universities of law and economics, when they work out together along with the the Ministry of Law in the as a part of body of the Law Commission, should guide both on what has been done as well as what is suggested to be done, so as to provide a pathway in which we make sure that we pass through the a correct direction. Giving a one statement about Justice Sikri, it happened to me when I used to be in the MTNL long back. Justice Sikri was instrumental and expert on the subject of 443, all telephone disconnection and all consumer related matters, and therefore he do understand and appreciate when he said that the economic evidence is crucial. When he talked about the Shiv Shakti case in the environmental matter, and he also says that how it adversely impact the infrastructure as well as impacting the other parts. It is also important to recognize and appreciate Justice Shri Krishna when he talked on the economic dimensions in the judicial decision, and it is not something which has come just now. To be honest with you, the famous economists like Ronald Coase and Richard Posson, when they emphasize the importance of efficiency in decision making and how the law and economics can work together for the betterment of the society. And as per, before I close, as per the Montesquieu doctrine, which talks about the three organs of the state, they have to work together and ensure that if the judiciary has taken a decision, because we all know judiciary cannot be competent in all these spheres, which Mehtaji has rightly pointed out, that these supporting functions have to be available so that the decision which is impacting the public at large, and mainly those which are not there in the picture, so as to be taken care of. And recently, in 6th March 2024, when the government of Kerala went to the Supreme Court and said that, that ceiling on the borrowing on the finances is really not very good, and there should be no limit. And here Justice Suryakant as well as Justice K.V. Vishwanathan mentioned beautifully that so far as the India is concerned, it has a robust economy, and it is not merely on perception but also based on the facts and figures. And what is important, once the judiciary recognizes, like this statement as well as the earlier case of Renuka Shivgar, the purpose is for all these platforms is to ensure that we succeed and work in a coherent manner, be it a law from persons from economics, law, finance, as well as from all other disciplines concerned in a specific case, so that a team should guide the nation and the courts as well, so that we get the best fruits. And my all best wishes to Mehtaji's wonderful work. Thank you. Thank you very much, sir.
Thank you, Professor Chopra. Thank you. We have benefited from extremely exciting presentation by Mr. Mehta and equally insightful comments by two discussants. So it is clear from the presentation and subsequent discussion that as a country, as a nation, as a society, we have the basic ingredients of ensuring that there's a economic footprint in judicial decision making vis-a-vis economic matters. That's amply clear. I also want to reiterate cases, some of the cases that were pointed out, mentioned, cited by Mr. Mehta and Professor Chopra. One such case is Shiv Shakti Sagar Mills case. If you, I want to emphasize for the benefit of audience here, that if you get a chance, read the judgment by Justice Sikri and Justice Sapre. To an economist, it will be a delight. You know, if you have had any complaints in your life that Indian courts should be using economic reasoning, doing this and that, it will be an apple of your eye. It will be, you will find in that judgment more than we could ever ask for. Two judges, they cite Ronald Coase, they cite Justice Richard Posner. They talk about utilitarian principle, they talk about cost benefit analysis, they make a strong pitch and very persuasive case for economic reasoning in judicial decision making. In my view, actually, the court actually goes to the other extreme, bringing too much of economic reasoning. I'm saying this with full sense, that fully mindful that I'm an economist and would want Indian courts to be guided by economic reasoning in economic matters at least. So in this background that we have enough talent, we also have several people who are fully sensitive and capable of helping the process. We find, at the same time, we find that there's almost neglect of the talent and also wisdom within judiciary. For example, Justice Sikri and Sapre's case in Shiv Shakti matters, it finds very little citations mentions in subsequent judgments of Supreme Court and also High Court. And therefore, it is little puzzling that why this neglect is there. The other issue that I find puzzling is that Indian judiciary and Indian law, they do not need to borrow from elsewhere, from other jurisdictions. They actually don't even need to go to economists in several cases. For example, in case of 2G and captive coal allocations and their subsequent cancellation, it is an Indian courts, Indian judiciary could have used legal principles that are already there as a part of Indian law. For example, disgorgement principle is there. For any wrongful gain, the first thing that should come to mind is disgorgement principle. Whereas Indian courts seem to be touchy about anything that has a connotation or explicit mention of corruption. Corruption has been made a moral issue, a kind of sentimental issue, that any enunciation, any mention of corruption should involve most severe punishments regardless of economic consequences. To my view, a lot of problem of NPAs that was faced by Indian economy, it was triggered by judicial pronouncement when they cancelled 2G allocation, when they cancelled captive coal mines allocation. Lot of investment by power plants, steel plants, it went waste, complete waste. Whereas in such cases, as Mr. Mehta argued very persuasively, courts could have applied disgorgement principle. But then courts are not the only organ of the state that does not apply what is already there in the law, in our statutes. Our executive is equally responsible. Our both discussants, Mr. Prasad, Professor Chopra, highlighted, stressed the adverse consequences of litigation. There's excessive litigation. Government accounts for roughly half of it. And other striking thing is that government loses most of the cases. Together, it shows that there is very little screening being done by executive. So not only in matters, not only there is not proper assessment of bills, actually the cases, ordinary cases, are not being scrutinized carefully whether they will stand any legal chance of prevailing before a court of law or not. And to me, so our Honorable Prime Minister has been at pains making this, arguing that there's too much litigation from government side, we must stop it. But without fixing the incentive structure, it is difficult to persuade executive bureaucrats to go for screening of cases, that only select strong cases will go for litigation, others will be settled. To me, it is partly a matter of incentive structures that have been created, and other is that our social mindset. Our social mindset has become of mistrust. Academia mistrust bureaucracy. Bureaucracy will mistrust academia. Bureaucrats will not trust judiciary. Judiciary will not trust other organs. As a result, we have acquired tendency to pass the buck. That is why even when there is a arbitration award, and ministry should accept arbitration award, even those cases are being referred to courts. And it is socially, it is very, very costly. But point is that I'm summarizing what three speakers, honorable speakers, have highlighted to a great length. Now, these issues have agitated me also to a great length. And I have had occasions to interact with the High Court judges, Honorable Supreme Court judges. There's one thing, one point, this is my last point to three speakers, that you all three made a case. Mr. Mehta argued that maybe Supreme Court should be divided into two chambers. One should be constitutional and other should be quote unquote commercial. A similar case was made by two discussants in different forms when you argued for cost benefit analysis, impact assessments of bills and statutes. The other feature of our mindset, judicial mindset, is that Indian high courts and Supreme Courts, and here I'm quoting a highly learned judge, their mindset is of a constitutional court. So what I want to submit to Mr. Mehta is that Indian higher judiciary is not divided. It is actually, they perceive themselves as a constitutional court. It means that on any aspects, they come from constitutional provision point of view. That is part of their training. When that's part of their selection process, their assessment process, their training. So as a result, even when they should be looking at efficiency issue, they end up looking at issues of justice, social justice, equity, with almost complete neglect of economic consequences. So all this, the presentation, two discussions, and my remarks essentially mean that there's a ambitious agenda ahead of us, wherein we need to sensitize, have more such discourses, more such talks, seminars, presentations, writings, to sensitize the academic community, the policymakers, and more importantly, lawmakers and the judiciary. Thank you so much. I now invite some questions from the audience. If you have a question, please unmute yourself. Ask a pointed question and then unmute yourself. If you would prefer to ask your question in the chat box, that is also all right. I can read out questions for you. Audience, please. Very good. Very good. Charan, may I invite you to say a few words and close the session?
I think, yeah, there are a number of questions in the chat box, which you may like to consider. Some of them are interesting, but my own observation would be, I have been, associated with the financial world, and
sorry, Charan, sorry, I don't see the questions. If you see, can you please read them out?
Sure, I will do that.
I see several comments. I mean, their comments, they are mostly, they're appreciating the speaker and discussants.
Yes,
so
true.
that I can wait to.
Ram Singh, I have a question.
Yes, please. Yes, please.
I'm reading a message. What are the major challenges faced by the policymakers from bureaucrats for? And I just wanted to clarify in terms of Professor Devi Prasad, you can't have ex ante analysis of legislation. You can only do an ex post analysis. What you do ex ante analysis when a bill is up for discussion or consultation. And that is the time that is the only thing. But otherwise, ex post analysis has been done by us in many cases, particularly what we call regulatory impact assessment. Looking at using three tools, necessity, legality, and proportionality of various policies and regulations as to how effective they are or not. Now, Ram Singh ji and Devi Prasad ji both spoke about the fact about the lack of litigation policy. That was not an issue that we covered in this particular analysis or litigation, though we are talking about it elsewhere. And it is a very highly desirable thing that we don't have a national litigation policy, which is being discussed forever. Few states have adopted one. Karnataka is one. And even in Karnataka, in fact, Karnataka was the only one which adopted an act on litigation policy. That's a very good model which others could have followed, but it has not been followed. And therefore, it is a challenge for the policy community in India to push the government to have a national litigation policy. You see, the overall problem when we address this issue of litigation policy is the overload, the sheer overload of cases. And I did touch, though, in some of my recommendations, like court vacation, for example. In the recent 75th anniversary, even the Supreme Court Chief Justice referred to. There's a parliamentary committee on that. So we do have a lot of things which require legal reforms. But the point which I was making in this particular event and the book is, how do we ensure that that judgments are made in a manner which are the best possible? Now, there are two, let me share with you two downsides to it. you must look at the downside. Nobody has talked about that at all. It's the predictability that if you allow that kind of 142(1) to apply, then it could lead to discretion on the part of the judge, and it will not follow the clear path of. This is mentioned by Pinky Anand, the MOS for Environment Today, in a particular event. And I think even Montek Singh Ahluwalia said that, look, if you start diverting from the clear boundaries of law, where are you going to stop? Now, I mean, there are some counterfactuals which we must think of and consider as to this, instead of saying that, this is the only way and this is the best way possible. Of course it is, in many ways, and you quoted Postner, etc. Well, I've quoted all of them in my book, having studied all that, including many other counterfactuals. That as a part of our good research that we do is we always look at downsides and counterfactuals. Otherwise, it doesn't make sense to only portray the wood without missing the trees. So we have to look at all the trees possible, as we say. Now, a question by Dr. Mehta is that what are the major challenges faced by the policymakers from bureaucrats for recommending or implementing any policy? It's a very, very wide question, and it will require a whole day seminar to address. And the other question that I see is, I don't know whether there's any particular. There's by one. Are we missing the
Elephant in the room.
elephant in the room? Is this?
By Anthony Joseph.
Is he the Justice Anthony Joseph?
I don't know. I'm just reading
Yeah.
it. That's all.
Right. Is Mr. Anthony Joseph there? Are you the Judge Anthony Joseph? Political adventurism and its relentless onslaught on democratic, economic, and a host of other participatory practices continues to ensure a precarious perch for democracy in India on the three-legged stool of legislature, executive, and judiciary. The onerous task of propping up democracy in the world's largest democracy is hardly the sole responsibility of the judiciary. I agree, we are not talking about democracy at all. We are not talking about litigation policy. What we are talking about is whether the court applies its mind to the economic impact of it. I give you the example, very simple example, very commonsensical example, that has the court looked at the issue of livelihoods when it is looking at environment?
I'll just add to what Mehtaji is saying. Mainly Article 142 of the Indian Constitution, complete justice. That's all.
Yeah, it talks about total justice. Yeah, but there again, as I said, as Pinky Anand and Montek Singh Ahluwalia told me rightly that, where are you going to draw the line? It could lead to, more discretion in the hands of the judge. And don't forget that even corruption has seeped into all parts of our society. Many of the Supreme Court judges have been bought. And judgments have come out which have been ridiculous. We all know that. So what I'm saying is that these are the kind of downsides we must think of. And therefore, a committee headed by somebody like Professor Ram Singh would be more credible to look into any of these things rather than a committee headed by any Tom, Dick and Harry.
Sir, what you have just mentioned, I'll just add to it. At least 3 Chief Justices after their retirement in Taj Hotel, Delhi, I have heard them. One was Justice B.N. Khare, Justice Kripal, and the next one to him. And everybody said that the roots of corruption are there also in the apex court and given in different numbers.
I know personally.
Yes.
I have evidence personally. I'm not going to name anyone.
Required,
But
sir.
the fact is that, our corruption has seeped into our whole, society so badly that there is no section which is, devoid of it.
Just one point is, I think.
And therefore, we run the risk of, the judgments being,
just to
Jayalalitha's case in Karnataka High Court. This is horrible. And so evidently corrupt. Anyway, sorry.
Can I make a point? What I meant was, ex ante assessment of the bill, not legislation.
Yeah, Bill.
What-
Yeah.
we
That's
are-
what I said. You can do
Ah.
an ex-ante assessment of the bill, which happens.
Okay, what I intended was that, and that helps committees to look into closely. This I have personal experience. In 1990s, the R&D cess tax came for review. Somebody said we don't need R&D tax; it's creating problems. So then I went to the parliament debates. People like Pilu Modi were discussing, and the point they made in the discussion, verbatim proceedings, are exactly being quoted in 1990 by people who say R&D Act didn't serve the purpose, R&D cess Act. So they had advantage of private research. So bills require ex ante appraisal, which must be part of legislative process.
No, what I could understood, sir, basically like in our engineering, we call it as a whenever there is input, there is an output. After the output, you need a feedback. It can be positive feedback, it can be negative feedback. Yes, please.
Over to you, Ram Singh.
Yeah. Ram Singh ji must be busy. I must mention that we have had an extremely interesting discussion.
Sharon,
And
could
each
you
one
just
of-
open your video?
Yeah. So I just want to thank each one of you for an exceedingly interesting discussion on a topic which is rarely researched and much needs to be done. Each one of you, of course, Mehta ji has written a complete book. Professor Ram made an introduction, and both of you, Mr. Devi Prasad and Dr. Chopra, you have made your contribution. I really want to thank each one of you for this discussion. Much needs to be discussed. Corruption is just, I know there's been a long debate between all of you on corruption. Yes, but there are many other issues that need to be discussed, which is a mix of law and economics. We need to look into it. I am happy to mention that EGROW Foundation has been talking on these lines for a couple of years now, and we want to do an educative course on economics for business for the law professionals, and we do offer trainings regularly, as you would have seen on our website, or might have got an email that we keep doing it every 3 months. We have done a special series on IBC. I would now like to
Charan Singh,
would-
can I just respond to the point which you made, which is what I've been asking you to do, is to do a course on microeconomics or behavioral economics for
Yeah,
judges
you did.
and
You did
Yeah.
talk to me about that, and we look into
we
it.
don't have that in our country in that manner in which and that is what even judges need to undergo.
I'm sure they need to undergo both the macro and the micro, and I will look into it. You did mention that to me, I remember so clearly. Okay, next week, we are going to have another session, and that is going to be on minimum support price. The key speaker is Professor Deodar from IIM Ahmedabad, and the EBW article that he has on the subject, where he moots another bright idea, is going to be the focus of discussion. I would like to invite all of you for that webinar. I would also like to mention that EGROW does lots of educational courses. Almost every day there's a class in the evening from 7:30 to 8:30, very nominally priced. And if somebody can't even afford that, we just waive off the fee. Our purpose is more of financial and economic literacy and not collecting revenue. And that is why we happily waive off, but we keep that nominal fee so that there's regularity and there is discipline and there is attendance. That's why we have kept it, but we would like you to spread the word. And those courses are taught by experienced economists, like chief economist of different institutions or other very well experienced economists. Some of them are from elite universities like JNU who are doing these courses for us. So every evening, 7:30 to 8:30, we have a course where I think scholars, professors of economics, young aspirants, anybody can take the benefit, and I would like you to come. And we want to spread that word across the nook and corner of the country. Even the remotest part of a village in India should be able to listen to these best experts who are volunteering to be part of this exercise of economic literacy. So with this, let me thank each one of you, especially you, Mr. Mehta, then Professor Ram Singh for agreeing to chair it, my dear friends, both Mr. Devi Prasad and Dr. Chopra, to have spared time and been with us for this discussion. I'm going to do series of talks.
It was a great pleasure, Charan.